Welcome to New Zealand Data Ops Meetup. Small group here. But today we're going to be talking about consumer data rights. And we got Thanga, who is going to help demystify what this means as a whole. Now, a couple of things. We are looking for speakers for future meetups. So just if you don't know New Zealand Data Ops, we've been around for about 7 years now. And we've hosted some really, really cool speakers from even COVID analytics with the New Zealand government, trying to baseline and test what the effects to the economy was, to even DevOps head for large startups around the world. What we're looking for is anyone that wants to talk anything around data. It doesn't need to be technical. It could be business discussions. Just reach out to me and we could sort of tee up a time next year. The next slide is so today before we go to the intro to Thanga, we got rebranding. We're going to be rebranding the meetup next year, so that's going to be a big focus for us. And the session's also going to be recorded, so if you don't want your voice recorded, just let us know, I guess, at a high level. And this will go up onto our YouTube channel and LinkedIn eventually. And I guess intro to Thanga. So Thanga, who I've known for quite a long time, is a data architect. So she's come from a banking background, worked for utilities, for transport, logistics, been in the data industry for 20 years plus, I would say.
Health industry as well.
Health too, there you go. So rich experience. So Thanga's forte is data governance, privacy, master data management, and she comes from a background of actually implementing stuff versus talking about it, so implementing successfully. And she's got a passion for the privacy, data governance and security area. So with that, I'm going to hand it to her to sort of run the whole session.
Thank you. So let's look at what actually CDR means, or the consumer data rights means. So CDR is basically a legal right that will allow customers to control their data and share it with trusted third parties. So it is meant to give individuals and businesses greater choice and control over their data. So the New Zealand government has decided to establish a consumer data rights to enable this. So when we talk about the third parties, here we are referring to the banks and organizations, so that you can get value from the data that is collected and held about them. So this is currently active in banking and energy sectors in Australia, and it's expected to be implemented in other sectors in the future as well. So given that this has been implemented in Australia, especially in the banking sector, I think we will start to look towards Australia for some of how it was implemented, how CDR was implemented. So you can see that the CDR will cover both data sharing as well as action initiation. So when we talk about data sharing, this will allow individuals and businesses to share their personal data with trusted third parties to get value from the data that is collected about them. So this will enable customers to switch between service providers more easily, as they will be able to take their data with them when they switch. So this is meant to give increased competition and ultimately benefit the customers with reduced prices and improved product offerings. And then we look at what is action initiation. So CDR will allow customers to initiate actions on their data, such as correcting errors or deleting data. For example, if a customer finds an error in their credit report, they can initiate a correction request through the CDR. So let us look at what the current state is and what the future state is, and why did we actually come up with this CDR, the consumer data rights. So if you look at the current challenges with traditional interbanking, so when we talk about consumer control and consent, customers have got limited control over their data. So banks hold the data without active involvement or explicit consent. So if you look at interfaces for data sharing, so legacy systems often lack standardized interfaces. So interfaces becomes really difficult with different banks and financial institutions, and they actually might require some custom solutions and bilateral agreements and so on. The other problem is, because banks traditionally relied on factors such as interest rates, service fees, and customer service, the competition is generally not there is not much competition, you can say. And also, data portability. When we talk about data portability, we are talking about moving and transferring financial data between banks. It's often very complex and very time consuming. And banks generally operate in silos with limited collaboration with external parties. Innovation is often confined to what individual banks can develop internally. And also, when we talk about privacy and security measures, they're individually implemented by the banks. So there is no standardized way of doing it. So if you look at the future state, so we are saying how will open banking help mitigate some of these challenges? So when we talk about customer control and consent, we are saying that customers will have control and have the power to grant or revoke the access to their banking data. Then the CDR will also mandate standardized APIs. So this will ensure consistent and secure method of data sharing between banks and accredited third parties. So this is meant to promote competition as well by enabling third-party providers to access customer data. This potentially could facilitate the development of new financial products and services, as well as more competitive offerings from different providers. With regards to data portability, moving and transferring of financial data between banks and service providers will be easier. So this will foster a more dynamic financial services ecosystem. With regards to innovation and collaboration, this will encourage by allowing third-party developers to create new apps and services that will leverage the banking data. And even with regards to privacy and security, there'll be it'll be a standardized privacy and security measures that will be implemented. So when we talk about the accredited data recipients, they must adhere to strict standards to ensure the protection of customer data, enhancing overall security and reducing the risk.
The third parties don't get stored. Third parties don't get stored.
Third
parties are just
no, they will get to store the data because we are talking about data recipients, right? So we've got a data holder and we've got a data recipient. So the accreditation is a process of saying that, I have the right to actually get the data from the holder. But you would need a mechanism to store that because you need to actually analyze the financial behavior of that particular customer. So you will. Yes.
Provide services.
Yes. So in summary, we are talking about CDR. It focuses on individual control over their personal data in the context of data privacy and protection. So it addresses issues like consent, transparency, and security. So CDR is currently implemented in Australia. So the two sectors that's already been rolled out to is the banking and the energy sector. So with regards to banking data, you can share information like your transaction history and account details with the accredited third-party service providers. So in the energy sector, you can explore better energy plans, compare prices, and make informed decisions about the energy consumption. So this is meant to break the data silos, which is held by traditional providers, which could result in better services and pricing for customers. So if you look at a use case scenario, let us assume that I've got an account with Bank A, and I'm looking for some better mortgage rates or something like that. So, you've got a service provider who is the accredited third-party provider. I will show an interest to say that, I'm interested in better mortgage rates. So the process would be that I would log into my bank and then I'll say that, I'm going to give explicit consent to say that, this third party can actually access my financial data. So then the third party will actually use standardized APIs and so that they can analyze your financial behavior, income and expenses, and they can provide recommendations tailored to my financial profile. So what is CDR? So CDR comprises of, it is supposed to give you data portability. Obviously, consent management is quite a big thing. Then access and control, security and privacy, and also regulatory oversight. So the goal of CDR is to give more control to consumers, more transparency to consumers, and more choice to consumers. So we're talking about, innovation and collaboration, and also coming up with better product for the consumers. So we've already gone through some of the challenges we face, limited data portability, the lack of consumer control, data privacy concerns, data accuracy, especially with regards to, credit reports and other financial records. Regulatory compliances, aligning with data protection and privacy regulation. Standardization, we talked about standardized APIs so that you can have a standardized way of transferring information between service providers. And financial institutions and third-party providers must implement robust security measures to protect consumer data. So what is the approach? So what is in the bill? So if you look at what the bill will contain, it will establish a framework which will give customers more access and control to their data. You'll have a standardized method of exchanging the data by taking on and adopting industry standards. You will be accrediting those who are trusted to request the data, requesting and also actioning based on the request of the customer. So what the bill does? So the bill will keep customer consent central to everything. So it will require designated data to be provided on request, potentially apply to the whole economy. We did mention that the banking sector is the first one to be rolled out, and after that it will be the energy sector, and then we have got few other sectors that will be included. So we are saying potentially it could apply to the whole economy. So it will rely on Privacy Act as much as possible. So what the bill does not. So it does not govern the creation, collection, storage, or deletion of information. So it will not change the rules about data ownership or where the data should be stored. It will require data to travel via the government. It does not require that. It will not create any new process for the government to collect or view customer data. It will not require new data to be created about customers, and it will not allow businesses to share your data without your consent. So if you look at the first sector is banking to be rolled out in NZ CDR roadmap. So the process to develop the NZ's CDR regime has been ongoing since 2020. So public submissions process was closed in July of 2023, and it's currently in legislation for government's round of approvals. So in the case of Australia, Australia's Commerce Commission made the foundational rules for CDR in February of 2020. And then CDR in the banking sector was rolled out in July 2020, and then the energy sector in October of 2022. And the next one in Australia will be the non-bank lending sectors. So since the draft law is already in the legislative process, it may continue through the legislative stages. The bill may proceed through readings and the committee reviews and debates, regardless of the change in the government. It would generally depend on the new government's approach to privacy issues and whether they will seek to amend or reform existing legislation. So let us look at who are all the participants. So, we have talked about who is going to enforce CDR. So Ministry of Business, Innovation and Employment, they are responsible administrator for the administration of CDR. If you look at Commerce Commission, they are responsible for enforcement. This will also include penalties and infringements. They are responsible for that. So they have proposed a 4-tier of liability. So the tier 4 is very severe, where you have severe breaches and infringements. In that instance, it could be imprisonment for about 5 years, and the dollar amount could be in millions. And then you have tier 2 and tier 3, depending upon what the infringement is. And then you have tier 1, which is basically it's an infringement, but it's not of serious consequences. So Commerce Commission will be responsible for that. There is an overlap in the jurisdiction between the Privacy Commission and the Commerce Commission with regards to the enforcement. But as the rules become much more clearer, we'll get an indication of that one. So who are all the data holders? So an entity that holds data is obviously the data holder. The data recipient is someone who is accredited under the draft law from and who can request data from a data holder, or they can request an action by the data holder. Customer is obviously someone who is an individual or an entity who consumes a particular product. Then we have the last one, which is the outsourced providers. So outsourced providers may be contracted to perform duties or utilize powers on behalf of either the data holder or the data recipient. But the onus of it lies on either the data holder or the data recipient. They need to be accredited. This is an overview of some key components from a data architect's lens. So we already talked about data privacy and security. So CDR places very strong emphasis on data privacy and security. So when you do your data architecture design, it should comply with privacy regulations and include robust security measures to protect consumer data. Then we look at data access and consent, and also along with that is the consent management. So because that's quite crucial. So it will give consumers the right to access their data and share it with authorized entities. So when you look at the data architecture, you should be able to enable secure and controlled access to consumer data while requiring proper consent. So consent management is again about consumers having the right to control their data and revoke consent. And then we come to the authentication, the API integration part of it, which is basically you have to implement strong authentication and authorization mechanism. Since CDR is implemented through standardized APIs, so that will allow you the data sharing between organizations. And then we have data portability. So, it should be quite seamless when you transfer your data between service providers. Obviously, you have to ensure that, there is integrity and security to it, along with data quality and accuracy as well. It should include data validation and quality checks to ensure the integrity of your shared data. So regarding auditing and logging, it does mandate that you keep transparent record keeping of data access and sharing activities. So you incorporate audit and logging capabilities into your architecture to track data usage. You need to understand the entire life cycle of your data, how it is being collected, how it is being stored, how it's being shared, and its eventual disposal and even compliance at every stage of it. Data governance practices is quite a big component of this, because you need to monitor and enforce CDR related policies and procedures. And obviously documentation is a given. You have to have proper design documents, data flows, security measures, and data access controls to demonstrate compliance to regulatory boards. So what does the CDR journey for data holders and recipient look like? First is obviously the understanding of CDR regulations. So whether it's a data holder or a data recipient, they need to familiarize themselves with the CDR regulations and standards. You have to register and gain accreditation, so they must demonstrate compliance. Consent management, as I mentioned, is quite a big component of that. So clearly explain to users how their data will be used and provide options to grant or revoke consent. Implement mechanisms for users to manage their consent preferences within the app, allow them to review and modify data sharing permissions easily. Obviously, authentication and authorization mechanisms are also very crucial. So for the data holder, you would need to develop CDR compliant APIs for accessing consumer data. And in the case of data recipient, it will be the CDR compliant APIs that they would be integrating these APIs into their product to fetch the required data. So ensure that you follow API documentation and guidelines provided by the data holder. Data encryption and security, implement strong data encryption mechanism and protect the sensitive consumer data you access. Ensure that data is transmitted and stored securely. Data holder is meant to provide a testing or a sandbox environment so that you can test your APIs, so that the recipient can make sure that it works smoothly and securely with the bank's system. These are some of the tasks for the data recipient. So stay compliant with CDR regulations, report any data breaches or security incidents to the appropriate regulatory authority and the data holder. Provide clear support channels for users who have questions or issues related to data sharing and consent. Clearly outline your product's privacy policy and terms of use related to data sharing and CDR integration. So make this information easily available to users. Regularly review your product compliance with CDR regulations and data holders requirements, and update your app as needed to maintain compliance. Provide educational resources within your app to help users understand CDR, their rights and benefits of data sharing. So if you look at consent management, we have got obviously to capture the duration of the consent, and then, it should be easy to go and modify or revoke their consent. And then, customer awareness, obviously, so support channels and what is the terms of use. And also educational resources where it helps to understand what their rights and benefits are. So if you look at the duration of the consent, in Australia, it is a 12-month expiry period. And in UK, the open banking system has an expiry date of 90 days. They haven't come up with it yet. Yeah. So those will be some of the things that they will define. So in summary, we talked about the key aspects of CDR. It's about access and control. So individuals have the right to access their personal data, know how it's used, and have control over its use. Consent is a big one as well. Explicit consent of individuals before collecting and processing their personal information. We talked about data portability. It is the right to request their data in a format that allows them to easily transfer from one service provider to another. Correction, you can request corrections to inaccurate or incomplete personal data held by organizations. Deletion, you can request deletion of your personal data under certain circumstances. So we looked at Australia. Australia has launched their CDR. The banking sector was rolled out in July of 2020, the energy sector in October of 2022. The legislation changes in New Zealand is most likely to happen. So if you do want additional information, MBI's website has got information about it, or please come and chat with us. Did anyone have any questions?
Yeah, what has the experience been like in Australia if you try to talk to how many companies or organizations fall foul of them?
What has their experience been?
Yes.
Oh, well, the fact that
the consumers as well.
they have put in a lot of money to actually expedite the process. So, and the fact that they did that with banking first and then they moved on to the energy sector quite fast within a span of 2 years, I feel like there must be an appetite for it. So those are some of the things that will be debated within the legislative, I guess, because they will look at the public submissions and so on. But also they will probably look towards what Australia has done and take the learnings from there and then adopt it. But then it will also come down to, will they be able to fund it to the level that Australia has done? Those are some of the things they'll probably weigh in. And
what does a breach actually look like? Is that a non-compliance? I can't assist my data.
It was some of the ones that they mentioned was they provided the data without the customer actually being authenticated.
Yeah.
Like, you need to have really strong authentication. And so those were some of the breaches. So they did have, mentioning, tier 4. In the case of Australia, there was an incident, I think in December of 2022, one of the banks, ING Bank. So they have, the way they look at it is a bit different. They've got listed corporation and non-listed corporation. So the fines is quite different. So in this case, the ING Bank, I think there was an infringement, and the amount that they paid was probably like 30 or 40,000. But if it was a listed corporation, it would have been exactly 10 times that. So it would have been 300,000. So, the way they look at penalties is a bit different. So we'll have to see how the Privacy Commission will come up with, the tiers for the liability.
How has the uptake been? I don't know if you know about the Australian market, but how has the uptake been in terms of the providers coming on board and providing services?
Yeah, because I think it is the first one is the banks. And I feel like, with regards to banks, already they have got quite strict privacy laws and things like that. So I feel like to a certain extent, it's much more easier for them to do it. So if you look at, the bank will be both the data holder as well as the data recipient, because, you will probably transfer from one bank to the other, right? So you will play the role of both the holder as well as the recipient. So in that instance, I feel like it's a bit more easier. Whereas I feel like with the energy sectors and all that, and the chances are that people will move much, more often than they do in a banking. For you to move between two banks is not it's not something that people do quite often, I feel. Whereas the energy sector and the telecom sectors, I would assume that people would move between those service providers much more often. So.
Don't you think that maybe the portability is precluding people from banks?
Yeah. Yeah.
That's a real pain.
Yeah, definitely. And plus, even when you move, currently you can't take all your transaction history and things like that. So, if you start from a new bank from scratch, then, your history is not there. So obviously nobody can tailor any new products based on your history. So, that's the other.
Any other questions online?
Keep going. Got a few questions. There's not lots of questions.
I've got a question about the consent. If you get your consent to share the data, so what about the consent to how that data can be processed? And what about the result of that processing? So if I get a bunch of data about your transaction history and I derive from that the creditworthiness score, where does that fit in the scheme of things?
Yeah, I think they're going to be really very clear on how it's going to be used and how it's going to be stored, how it's going to be, eventually when it gets disposed, how it's going to be done. So I think there'll be.
The data. I look at the data, something I've generated myself. So I could delete everything but share with me. That's all got this result blend. How's they doing with that, Oscar?
Yeah. Yeah, something to think about. Yeah.
I think there would be. It might come under the Privacy Act. So there'll be rules. There'll be rules for everything. I think it's all of the other side of it where you'd have to go to that. The receiver, say, give me all the data you've got on me, and by the way, I want you to delete that. So there's enough levers in the legislation to allow you to clean up after yourself. But from what you've said, there's nothing more that forces the receiver to clean up.
Because you did go into sort of conditional consent forms and saying, I'm allowed to do that, but not this. Particularly at 90 days, it seems like quite a high refresh rate consent every 90 days.
So for UK.
12 months.
What is the overhead or admin overhead do you think for becoming a certified recipient? Again, the big guy,
I think the banks will be fine. I think, I feel like for when you go into the energy sector, I think it will be quite steep. I feel, that's my feeling. Because I think with the banks, they already have quite a few of those measures in place, and they have quite strict, yeah.
Okay, so I think we could wrap up there. So thank you, Tanga, for that. That was really informative. Yeah. And what we'll do is we will take this recording and put it on YouTube on the NZ Data Ops channel. And again, just reach out if you want to speak the next meetup in the new year. Thanks, everyone.
Thank you.